We are live on YouTube, I guess. अभी या तो स्क्रीन शेयर लगा दो कोई पोस्टर। नीलेश,
हाँ जी।
मैं ये कह रहा था कि ये अलाउ ऑल कर दो, अब एडमिट वाला सिस्टम खत्म कर दो।
ओके
तो कोई भी आइडिया कितनी देर तक हम करते रहेंगे सबको।
डन।
ठीक।
हाँ जी। हाँ जी।
मैं ये कह रहा था कि ये अलाउ ऑल कर दो, अब एडमिट वाला सिस्टम खत्म कर दो।
कर दिया। ओके
तो कोई भी आइडिया।
हेलो। जी नमस्कार।
अखिलेश, आपके पीछे लाइट आ रही है जो पीछे।
जी नमस्कार।
नमस्कार नमस्कार। ठीक है।
ठीक है पदम जी।
यस यस।
पदम जी जब स्क्रीन शेयरिंग स्टॉप करनी हो तब बता देना।
नीलेश जी, मेरी आवाज आ रही है ना आपको?
हाँ हाँ, आ रही है। ठीक है, आ रही है। अभी 5:25 हुए हैं। ठीक है।
जी हाँ।
5:32 पे स्टार्ट। अखिलेश, नीलेश एंट्री पे अनम्यूट क्यों नहीं हो रहे, म्यूट क्यों नहीं हो रहे लोग?
कौन?
जैसे कोई एंटर कर रहा है तो अनम्यूट कैसे आ रहा है?
अभी देखते हैं।
म्यूट करना पड़ रहा है। नमस्कार राकेश जी।
नमस्कार जी परम जी।
ठीक
आ
है
रही
जी।
है आवाज?
हाँ जी, हाँ जी।
नहीं म्यूट ही है, एंट्री पे म्यूट है खुद।
फिर कैसे म्यूट करना?
नमस्कार जी परम जी। आ रही है आवाज?
देखो नीलेश जी, सारे अनम्यूट आ रहे हैं।
एक मिनट। अब चेक करो,
फिर एंटर करेगा तब पता लगेगा।
एक बार कर दो सबको म्यूट।
म्यूट ऑल। अखिलेश जी, नीलेश स्क्रीन शेयर हटा दो।
हाँ जी सर।
स्टार्ट कर। यू कैन स्टार्ट। ठीक है शेयर में। प्रतीक शायद अभी ज्वाइन नहीं किया, लेकिन देखने
Teak is already here. I think we can start. His video is off.
देखिए इज नॉट हियर, इज नॉट इन द लिस्ट ऑफ पार्टिसिपेंट। नहीं, वो लॉग आउट हो गया इसका ना गलती से।
Okay.
हाँ ओके, ही इज हियर। ठीक है, ठीक है, ही इज हियर।
क्या गया?
बात करें अखिलेश जी। अखिलेश, अखिलेश जी।
मुझे तो दिख नहीं रहा। हाँ फिर तो चला जाता है। चला गया। हाँ।
ऑर्गेनाइजर्स को एक बार फोन करके तुम बोल दो आईपैड से कनेक्ट कर लो फटाफट। ये लो जस्ट इन्फॉर्म देम वंस।
हाँ जी। अखिलेश जी आगे क्या?
नहीं, उसे हमला हो गया।
अखिलेश जी आगे क्या?
नीलेश स्क्रीन शेयर बंद कर दो।
नमस्कार दोस्तों। मैं अखिलेश व्यास, महामंत्री अधिवक्ता परिषद पंजाब। आज आप सब लोगों का स्वागत करता हूं अधिवक्ता परिषद के 6th ऑनलाइन स्टडी सर्कल में। और आज के हमारे मुख्य वक्ता हैं श्री प्रतीक महाजन जी। और आज का जो हमारा विषय है वो है रिसेंट चेंजेस इन द आर्बिट्रेशन लॉ इन इंडिया। So this topic is very important from the litigation point of view as well as from the academic point of view. तो प्रतीक महाजन जी आज हमारे साथ ये टॉपिक शेयर करेंगे। As far as the academic background of श्री प्रतीक महाजन जी is concerned, प्रतीक महाजन जी शुरू से ही अपनी स्कूली अपनी स्कूलिंग के दौरान शुरू से ही क्लास टॉपर रहे हैं। और उसके बाद जहाँ तक BLLB का सवाल है, BLLB उन्होंने UILS पंजाब यूनिवर्सिटी चंडीगढ़ से
आप बंद कर दो यार, मैं कर लूंगा अपने एक मिनट।
and he was awarded as a gold medalist with by Justice T.S. Thakur, Supreme Court of India, from for being the university topper. And subsequently श्री प्रतीक महाजन जी ने अपने कॉलेज टाइम पे बहुत सारे मूट कॉम्पिटिशन्स में भाग लिया और 2 से 3 कॉम्पिटिशन्स में उन्हें बेस्ट स्पीकर और बेस्ट वक्ता के तौर पे भी अवार्ड मिले। श्री प्रतीक महाजन जी सिंस 2013 प्रैक्टिस कर रहे हैं पंजाब हरियाणा हाई कोर्ट में और प्राइवेट प्रैक्टिस भी कर रहे हैं और साथ ही में साथ वो कॉर्पोरेशंस और सेंट्रल गवर्नमेंट काउंसिल भी हैं। एंड ही वाज अपॉइंटेड एज सेंट्रल गवर्नमेंट काउंसिल in 2015 and subsequently Mr. Prateek Mahajan was appointed as panel counsel of Chandigarh administration on civil side of the cases at Punjab and High Court in 2017. He is also on the panel of Life Corporation of India and Kurukshetra University and Bhakra Byas Management Board of Cases at Punjab and High Court. He's also on the panel of Board of State of Haryana and Haryana State Pollution Control Board, Haryana State Agriculture Marketing Board and Haryana Vidyut Prasaran Nigam. तो आज का जो हमारा टॉपिक है वो प्रदीप महाजन जी से मैं रिक्वेस्ट करूंगा कि आज वो हमारे सामने ये टॉपिक रखें और हम लोगों को एनलाइटन करें विद रिगार्ड टू द टॉपिक फॉर टुडे। प्रतीक जी, कैन वी स्टार्ट? प्रतीक जी आपको प्रतीक जी अनम्यूट करना पड़ेगा एक बार।
हाँ जी हाँ जी हाँ जी
हाँ जी, नाउ वी कैन हियर यू
हाँ जी हाँ जी।
सर।
बहुत
मोस्ट
बहुत थैंक यू सो फॉर दैट जनरस इंट्रोडक्शन अखिलेश जी. We are only as good as they say as we are on the given day. So I'll try my best that I am able to share my knowledge to the optimum with all of you on this topic. As we know that arbitration in India is governed by the Arbitration and Conciliation Act 1996. But with passage of time, it was being found that the Arbitration and Conciliation Act was failing to achieve its objective of speedier, inexpensive, and effective resolution of disputes. This was because one of the very basic principles of arbitration, that is minimum judicial intervention, was one not being followed by our courts, and secondly, the arbitrators, sometimes because of not being professional enough, or sometimes because of their needs for charging high fees, etc., they were not proceeding with the arbitration in a speedy manner as desired as per the international best practices. So our government, which wanted to make India an international arbitration hub in tandem with the best international practices, brought in the 2015 amendment. And if I quote Justice Indhu Malhotra of the Supreme Court over here, she said, the 2015 amendment is perhaps the most significant milestone in the arbitration landscape of India. This 2015 amendment made large-scale changes to the Arbitration and Conciliation Act 1996 and brought it in tandem with the international best practices in our government's attempt to make India an international arbitration hub. After the 2015 amendment, it was found that there were certain creases which were still to be ironed, and therefore, to ensure that certain fine-tuning takes place, another committee was appointed, headed by Justice Sri Krishna of the Supreme Court, which suggested certain amendments, and thereafter the 2019 amendments were introduced. Apart from this, there is one more aspect which I'll be dealing in detail with the 2015 and 2019 amendments through a presentation which I made for all of you. Apart from this, there's one more aspect which I would highlight, that on 31st of October 2019, by virtue of the J&K Reorganization Act, the Arbitration and Conciliation Act is now equally applicable to the state of Jammu and Kashmir. Earlier, J&K had its own Arbitration and Conciliation Act for domestic awards, but now by virtue of the new act in 2019, J&K is also governed by the Arbitration and Conciliation Act. Now, Akhilesh ji, with your permission, I would like to start with the presentation so that I can make this more easy and convenient for everyone to listen to me and to see what I'm trying to say.
Yeah, definitely, sir. Kindly proceed with it.
Just a second, let me just log. Start with the screen sharing. I'm sorry, it's just taking a little bit of time. Connecting. Just give me 1 minute. Okay. Right. So as I've already discussed, there are three amendments which have taken place in recent time, which I'm going to be discussing with you, and the most important one being that of 2015. Now, the important date which I want all of us to note in this regard is 23rd of October 2015, since this is the date on which the amendment of 2015 had come into force. Initially, the government had promulgated an ordinance, and thereafter the act had come into force on 1st of January 2016, but it had come into force with retrospective effect. So if we have to see the date from which the amendment will apply to arbitral proceedings or to court proceedings, we have to look at this effective date, which is 23rd of October 2015. Thereafter, the 2019 amendment had taken place. On some provisions of this amendment have been enforced, while others have not been enforced. I'll come to that in a short time. Now, the objectives of these amendments, I have briefly discussed that the arbitration in India was failing to achieve its objective of speedy and inexpensive resolution of disputes. But one major thrust of these amendments is on encouraging institutional arbitration as opposed to ad hoc arbitration. So here I would like to briefly explain how is ad hoc arbitration different from institutional arbitration. Institutional arbitration refers to an arbitration where the entire process of arbitration is governed by a specialized institution, right from the process of appointment of arbitrator to the procedure of arbitration, to the law relating to arbitration, the schedule of fees, etc., uh, and the administrative machinery. All of this is governed by the rules of an institution, which helps in making the arbitration process smoother. For instance, in India, the most prominent arbitration institutions are the New Delhi International Arbitration Center, the Mumbai Center for International Arbitration, and a Nani Palkiwala Arbitration Center, which is in Chennai. So since these organizations, they have their specific administrative machinery, they have a panel of professional arbitrators, they have a fixed schedule of fees as part of their rules. It is felt that if India progresses from ad hoc arbitration to institutional arbitration, it will result in the Arbitration Act achieving its objective, and the disputes will be resolved in a much more speedy and effective manner. Secondly, it was often felt that in many of the cases, the ad hoc judges, who often used to be retired judges as arbitrators, they used to charge exorbitant per hearing fees, and sometimes the amount of fees rose almost to as much amount as the claim itself. So in the Arbitration and Conciliation Act, now a schedule has been introduced for governing the fees relating to arbitrators. Also, now timelines have been fixed as to how and within which period the arbitration is to be conducted and the relating court proceedings are to be conducted. And just like in CPC, provision has been made for day-to-day hearing so as to avoid the culture of frequent adjournments. Also, going by the principle of minimum court intervention, which forms the foundation of arbitration, now it is required that the courts under Section 8 refer the disputes to arbitration so long as their prima facie satisfied that there is a valid arbitration agreement. So the scope of interference of the court has been reduced. And similarly, under Section 34 also, by restricting the definition of the word public policy, the scope of interference of the court has been reduced. Now, section by section, I would like to highlight the important amendments that have taken place. Firstly, coming to section 2(1)(e), which deals with the definition of court. Earlier, the definition of court was a principal court of original civil jurisdiction in a district. So for Punjab, Haryana, and Chandigarh, this would imply the district court or the additional district judges functioning under the district judge. Now, after the amendment, a distinction has been carved out between domestic arbitration and international commercial arbitration. So far as international commercial arbitration is concerned, the court will always mean the High Court, and so far as domestic arbitration is concerned, the original definition has been kept, that is the principal civil court of original jurisdiction. So this is one change, that international commercial arbitration should be dealt by the High Court always. And then similarly, amendments have been introduced in Part 1 of the Act explaining as to Part 1 will be applicable to which arbitrations. Earlier, Part 1 of the Act used to govern all those arbitrations which are in India, whether they were international commercial arbitrations or they were domestic arbitrations. Still, the position is restored, but now even if the arbitration is taking place outside India in a foreign jurisdiction, there are three provisions which have been made applicable. These are Section 9, which relates to interim measures, Section 27, which talks about court assistance in taking evidence, and Section 37, subsection 3, clause B, which deals with appeal in case of interim measures. So if even if the arbitration is taking place in a foreign country, if one of the parties feels that the subject matter of the dispute is in India and they need some urgent interim measures, they can approach the competent court of original civil jurisdiction. Whereas prior to the amendment, this provision was not there, and in arbitrations taking place outside of India, the parties could never approach the courts in India. Now, another important amendment which has taken place is with respect to the meaning of agreement for the purpose of constituting a valid arbitration agreement. So now even communication through electronic means has been recognized as an agreement in writing. So merely if in a case that where two parties have exchanged emails or even messages which clearly signify their intention to enter into an arbitration agreement, that itself can constitute a valid arbitration agreement in writing. So the scope of the words in writing has been expanded to include electronic means. Now coming to the next section, which is Section 8. Section 8, 9, and 34 are of course the most important section when it comes to litigation practice. So Section 8 is the section where, of course, the court power has been given to the court to refer the parties to arbitration in case of a valid arbitration agreement, and in case an application is made by the party before submitting the first statement on the substance of the dispute. Earlier, it was found that the court or the judicial authority, as is defined under Section 8, if it often used to refuse to refer parties to arbitration on several grounds, such as fraud or non-arbitrability of disputes, or limitation, or saying that mutual satisfaction has already been recorded, and hence the agreement is discharged. Now, in order to reduce the court intervention in such matters, a non-obstante clause has been added in the beginning of Section 8. The effect of this clause is that the earlier judgments of the Supreme Court, I have referred to two judgments over here, which said that issues of fraud and similarly certain other matters such as rent matters, etc., are non-arbitrable. So effect of this non-obstante clause is that these judgments are now obliterated, and even in these cases, the court can refer the parties to arbitration so long as they are prima facie they are of the opinion that a valid arbitration agreement exists. Another change which has been made is that not only the party can apply, but now any person claiming through or under him can also apply. So this was an error which was required to be corrected, and this has now been done. Secondly, in Section 8, earlier there was a requirement that the party had to always produce the original or the duly certified copy of the arbitration agreement. So now, similar to the kind of provisions which we have in the Evidence Act, say Section 65 and 66, there's a provision that if the original agreement or the certified copy is being retained by the other party, you can file an application to the court that asking for the other party to produce the original arbitration agreement, and along with the application, you can file the copy of the arbitration agreement. It can be accepted by the court as long as it is proved that the other party is retaining the agreement. So these are few important changes that have been made in Section 8 so as to make it more convenient for the parties to enter into arbitration. The next important section is Section 9, which deals with the interim measures or the powers of the court to grant any stay or interim measures of that sort. Now, one change that has been made now is that Section 9, Section 17 have been made analogous. That is, the arbitral tribunal has the power to give all those interim measures which the court has under Section 9. So the intention of the legislature is that as far as possible, the interim measures as far as possible, interim measures should be granted by the arbitral tribunal only, and the parties should approach the arbitral tribunal. In fact, another subsection has been introduced which says that the court shall not grant any interim measure or shall not entertain any interim application unless circumstances exist which render the remedy under section 17 of the act not efficacious. So once the arbitral tribunal has been constituted, it is always the arbitral tribunal which has to grant the interim measures, and only in an exceptional circumstance the court has to intervene. And also, a lot of times it used to be seen that parties used to take interim measures under section 9, and then for months altogether no arbitration proceedings were instituted and the benefit of stay was enjoyed. So to curtail this practice, another subsection has been introduced which provides that within a period of 90 days the arbitration proceedings have to be commenced in case an order under section 9 is obtained from the court. Now, then coming to section 11, which is of course a very important section when it comes to practicing before the High Court. Section 11, which deals with the procedure of appointment of arbitrators. First, of course, just like every other section, arbitration is governed by party autonomy. That is, the agreement between the parties has to prevail over everything else. But in case the parties are not able to act according to the procedure prescribed in the agreement, there was a provision earlier that the parties could approach the Chief Justice or any person or institution designated by him to appoint an arbitrator. In this, it was again found that the Supreme Court had held in a 7-judge bench in SBP versus Patel Engineering in 2005 that this is a judicial function, and therefore the Supreme Court used to decide a lot of issues before referring the parties to arbitrators, such as the territorial jurisdiction, the existence of an arbitration agreement, whether the parties have recorded full satisfaction, and also limitation. I've referred to one judgment of our High Court where it was held that if the claim is barred by limitation, the arbitration application will be dismissed. So now, after the amendment, it was felt that there needs to be a curtailment of court interference, and most of the cases should be referred to the arbitrator, and the arbitrator should look into these issues as far as possible, and the preliminary issues should also be decided by the arbitrator. So now, after the amendment, section 6A has been inserted, which is a very important provision, which says that the Supreme Court or the High Court, while deciding the application under this section, shall confine to the examination of the existence of an arbitration agreement, notwithstanding any judgment, decree, or order of any court. So all the other 3 or 4 grounds which I have enumerated before amendment now no longer cease to exist, and the court should only look into the existence of an arbitration agreement. A non-obstante clause has been given so that the earlier judgments of the High Court and the Supreme Court are obliterated. Also, earlier the word used was the Chief Justice, and now it has been changed to Supreme Court or High Court to indicate that it is a judicial function which is being discharged by the Supreme Court or the High Court. In fact, this was done in the 2015 amendment, and now in the 2019 amendment, the word Supreme Court has also now been replaced by arbitral institutions, Supreme Court and High Court. Although these provisions relating to arbitral institutions appointing arbitrators have not yet been enforced by the government. So as on today, the position is still that the Supreme Court and the High Court have to appoint arbitrators. But section 6A, as inserted by 2015 amendment, is very much in force, which says that the court will only confine itself to the existence of an arbitration agreement. So while I say that the court will only look at this, but would this mean that there are no issues whatsoever which are to be seen while deciding an application under section 11? 2 or 3 recent judgments I would like to refer here, which I feel all of us should note and which will be important while dealing with such cases. Firstly, a very recent judgment of the Supreme Court, which deals with the issue of stamping or non-stamping of contracts. So the Supreme Court, relying on its earlier judgment in 2011 in Garware Wall Ropes Limited, in this case, the Supreme Court has held that if the original contract is unstamped and not properly stamped according to the Stamped Act, then the arbitration clause in such a contract will also not be enforced or acted upon. So even if the court is looking at the existence of an arbitration agreement, that does not mean that the respondent or the defendant cannot take any pleas. There are still pleas available with us. Another plea which is relevant in this case is the issue of whether there, in case in the arbitration agreement there are certain preconditions provided, whether they have to be fulfilled or not. In this respect, I want to refer one recent judgment. You can I have given the civil appeal number. This is a judgment by Justice Rohington Nariman of the Supreme Court, whereby he struck down clause 25, subclause 8 of the contract in that case, which was relating to Punjab State Water Supply and Sewerage Board. Similar clauses are perhaps found in most of the contracts relating to Punjab corporations. And in this clause, there is a provision for a pre-deposit of 10% of security amount. It could be 10% or any other amount. And further, the provision in this clause was that even if the claimant is successful, he'll be entitled to refund of only the proportionate amount to the amount awarded by the arbitrator. So if I give an example over here, for instance, I file a claim for rupees 10 lakhs and I have to deposit 10% as security deposit, which will be rupees 1 lakh. Then if the arbitrator ultimately awards me 5 lakhs out of 10 lakhs, out of my security deposit of rupees 1 lakh, 50% will be forfeited, since the arbitrator has given me only 50% of the amount. So I'll get back only 50%, and that is rupees 50,000, and 50,000 rupees, which is the remaining part of the security deposit, shall stand forfeited. So this was found to be highly arbitrary and unreasonable by the Supreme Court, that even if a party is successful, portion of the security deposit was being forfeited. But while this applies to a lot of cases in Punjab contracts, I need to point out that the Supreme Court in this case was headed by a 2-judge bench, and there's a larger bench of the year 2009, which is a 3-judge bench in SK Jain versus State of Haryana. I've given the citation. In this case, the clause provided that in case the claimant is successful, after adjusting the cost, the balance amount will be refunded to the claimants. So in this case, there is no unjust enrichment of the state, insofar as if the claimant is successful, he'll get back the security amount. So this clause has already been upheld by a larger bench, and going by the doctrine of precedents, we can still argue in a given case-to-case basis that this judgment, which is a 3-judge bench of the Supreme Court, will prevail over the recent 2-judge bench of the Supreme Court. I think this judgment all of us should note, because the recent view which is prevailing in the courts is that they are relying upon this judgment by Justice Rohington Nariman and setting aside the clauses in all cases, whereas, as I've explained, the clauses have to be seen on a case-to-case basis, and this objection is still open to be taken in Section 11 petitions. Then I've referred to another judgment by Justice Krishna Murari while he was he was the Chief Justice over here, in which he has also dismissed a petition after the amendment, stating that the preconditions in the arbitration clause were not specified, were not satisfied. As we see often in a lot of government contracts, there is a clause that parties in case of a dispute shall refer the matter to the general manager in case of railways, or say the chief engineer in case of a lot of corporations, who will first decide the dispute and take a decision within a specified period. And only if he fails to take any decision within the specified period, the party shall approach the arbitrator. So in a given case, if a party has not approached the concerned officer and straightaway approached the court for appointment of arbitrator, the arbitration application can be dismissed in such a case, as has been explained in this case. You can put down the citation. Nature of power under Section 11, this I've already explained, that pre-amendment position was that the power exercised under Section 11 was treated to be a judicial power. The judgment is a 2005 7-judges bench of the Supreme Court in SBP versus Patel Engineering. Now, after 2015 amendment, one clause has been inserted, which is subsection 6B, which state that in case the Supreme Court or the High Court delegates its powers, that is, it designates any person or institution, it shall not be regarded as a delegation of judicial power. So attempt is that if there is any delegation by the High Court or the Supreme Court, say to an arbitral institution, it should be treated as an administrative power and not as a judicial power. Next important aspect is the determination of fees of the arbitrators, which is often a huge bone of contention. Prior to the amendment, it used to be the parties themselves in their agreement, which had to mutually settle the fees along with the arbitrator, and it was many a times found that the arbitrators used to charge highly exorbitant amount of fees on a per sitting basis. And now, under the provisions of the amendment, the High Court has been empowered to frame rules for the purpose of determination of fees of the arbitral tribunals. And it has been provided that it shall take into account the rates of fees specified in the fourth schedule. Now, in the fourth schedule, according to the amount of claim, different slabs have been provided as to how the calculation of the fees is to be made, and the minimum fees for claims which are less than rupees 5 lakhs is rupees 45,000. So it is still quite a handsome fees, and I think all of us should look into getting ourselves enrolled as arbitrators under the relevant rules which have been made by a High Court. So our High Court specifically has framed Chandigarh Arbitration Center Rules 2018 and has adopted the fee specified in fourth schedule. The effect of this is, as soon as the High Court frames rules under this provision, the fees under the fourth schedule, which has been adopted, now becomes binding on all arbitrators which are appointed by the High Court. So now on, this schedule is strictly applicable in all appointments which are being made by the High Court under Section 11 of the Act, unless the parties specifically agree to pay some different amount of fees to the arbiter. And secondly, this will not apply to international commercial arbitration and in cases where parties agree that their fees is to be determined by the arbitral institution, as I've already explained, that parties can agree to refer their dispute to an arbitral institution. The schedule of fees can be altered by this government from time to time. This has been provided in Section 11A. Now, it has been provided that there should be no letters patent appeal against such decision, which is in fact already the settled provision. So I'll not go so much into this. Another provision which is relevant is that in order to expedite this process, it has been provided that as far as possible, the High Court or the Supreme Court will try to decide this application within a period of 60 days. And in future, once the provisions of Arbitration Amendment Act 2019 are enforced, the arbitral institution which will be designated, it will have to dispose of the application within a period of 30 days. Although the provision with respect to the arbitral institution has not yet been enforced, and it is still with the High Court and the Supreme Court to decide it within a period of 60 days. Now, next is a very important portion contained in Section 12 of the Act. Now, as soon as a person is approached for his appointment as arbitrator, he has to make two disclosures. The first portion was already there, which that in case there was any justifiable doubts as to the independence and impartiality of the arbitrator, that such a disclosure will have to be made. But now, in addition, a new disclosure will have to be made by him as to any circumstances which are likely to affect his ability to devote sufficient time to the arbitration and to complete the arbitration within the specified period. Apart from this, a Schedule 5 has been inserted in the Act, which will act as a guidance as to the circumstances which constitute justifiable doubts on the independence or partiality of the arbitrator. There are 34 entries in Schedule 5, and all kinds of business, professional, personal relationships are sought to be covered under the schedule. However, mainly because it is an entry is mentioned in Schedule 5, a person will not become disqualified to become an arbitrator. A person will have to make a disclosure under the form provided in Schedule 6 in such a cases as to such circumstances. And thereafter, it is for the court to take a decision and the arbitrator himself to take a decision whether he should recuse in certain cases or not. However, there are there's another schedule, which is 7th schedule inserted in the Act as different from 5th schedule. In the 7th schedule, only the first 19 entries of the 5th schedule have been inserted. And in case a person is having any of the relationships which are specified in the 7th schedule, then he automatically becomes ineligible to be appointed as an arbitrator. For example, if I mention the first entry, it says that the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party to the dispute. So past all the present employees are automatically disqualified now from being appointed as arbitrators, as we used to see mostly in all government contracts relating to state governments or Union of India or statutory corporations. There used to be this clause that a high-ranking official of the government shall act as the arbitrator. So this clause is now no longer valid, and it has been held to be illegal in view of this provision. However, in one recent judgment, while present employees are disqualified from acting as arbitrators, in one recent judgment, the Supreme Court has said that ex-employees will not be disqualified from acting as arbitrators. In this case, the person who was appointed as arbitrator had retired about 10 years ago. So the court had made this observation. However, this has come under a lot of criticism, and most of the arbitral experts believe that since even ex-employees have a nexus with the organization, they should also be ideally disqualified from acting as arbitrators. The parties, if they have faith in any of the persons, even if he has any of these relationships, parties have the power to waive the applicability of this section. This is also provided. Now coming to section 17, which deals with the interim measures that are granted by the arbitral tribunal. Now, I have already said so that section 17 has been brought at par with section 9. The language which has been used has been made pari materia with section 9, and the arbitral tribunal can now give all those interim measures which the court can give under section 9. These measures can be granted only during the arbitration proceedings. Earlier in the 2015 amendment, it was said that the arbitral tribunal can pass measures under section 17 even after the arbitral award. However, this has now been changed, and it is only during the arbitral proceedings this can be done, since it was felt that this was contrary to section 32, that the mandate of the arbitrator terminates as soon as the award is pronounced. Another important provision is that under subsection 2 of section 17, the order made by the arbitral tribunal for grant of any stay or interim measures, it shall be deemed to an order of the court and is now enforceable under CPC. So a lot of times parties used to refrain from using section 17 and used to apply to the court under section 9 was because the provisions, because the order under section 17 was found to be not enforceable. But now this lacuna has been removed and the order has been made enforceable under CPC. Further, under section 23 of the Act, earlier also, although we used to file counterclaims earlier also, but some arbitrators used to accept it and some did not. Now the position has been made very clear, and the provisions of counterclaim and set-off have been incorporated as a defense on part of the respondent. Of course, it has to be within the scope of the arbitration agreement. Only then the arbitrator can act on such counterclaim or set-off. Another important provision which is relating to the timeline or for the pleadings which have to be filed before the arbitral tribunal. Now the Act says that the statement of claim and defense have to be completed within a period of 6 months from the date of from the date the arbitrators receive notice in writing of their appointment. So strict timelines are being prescribed under the Act so as to ensure that the arbitration is heard in a time-bound manner. And similarly, under section 24, it has been provided that after the pleadings are completed, the arbitral tribunal will try to hold the hearings on a day-to-day basis for presentation of evidence or for oral evidence, and adjournments shall be granted only in case sufficient cost is made out, and the tribunal can even impose exemplary cost in case adjournment is sought without sufficient cost. Now coming to section 28, this is a very important amendment which defines the scope of decision of the arbitrator. Earlier under section 28.3, when the arbitrator was deciding the dispute, the language used was the arbitrator will decide the dispute in accordance with the terms of the contract. So this was interpreted to mean that the arbitration will have very little scope to deviate from the terms of the contract. and he had to act strictly according to the contract, and if any term was found to be unreasonable, he could not interpret it in some other manner and go beyond the literal interpretation. But now the words "in accordance with" have been changed to "shall take into account the terms of the contract." And this has been subsequently explained by the Supreme Court in its judgment that this would probably mean that now the arbitral tribunal need not go by the literal interpretation of the terms of the contract, but it can give a more reasonable interpretation to certain terms which it finds when it feels that a certain term is unreasonable in a contract. The next provision, which is a very salutary provision, a new section 29A is inserted in the Act, which probably is one of its kind, and there is no such provision in any other jurisdiction of the world. Now, India has specified a particular time limit for arbitral awards under the Act. As I said, that 6 months was the period for completion of pleadings under the Act. Then further, after the pleadings are completed, it has now been provided that the arbitral tribunal will pass the award within a period of 12 months from the date of completion of pleadings. Earlier, it was stated in the 2015 amendment as 12 months from the date of reference, but in 2019, it has been changed to 12 months from the completion of pleadings. So if you add both of the same, so it's 6 plus 12. So ideally, an arbitral award should be passed within a period of 18 months now as per the Act. The parties, with their consent, can extend it by a period of about 6 months if they wish to do so. And in certain cases, in case the award is not pronounced even within the specified period, power has been given to the court to extend this period on application being moved by either of the parties. However, it shall be done only if the court is satisfied of a sufficient cause mentioned in the application and it can impose reasonable terms and conditions. Upon such application being moved, again, the court should endeavor to decide such an application within the period of 60 days from the date of service of notice on opposite party. Further, if the court feels that the extension is because of the arbitrator, power has been given to the court to reduce the fee of the arbitrator by an amount not exceeding 5% for each month's delay. So for 1 month's delay, the court can even reduce the fees by 5%. So in case the arbitrator delays the award by a long period, say 20 months, even the entire fee of the arbitrator can be forfeited by the court by passing an order under this section. Of course, the arbitrator in such a case should be given an opportunity of hearing before reducing the fee. Also, in case the court finds that the delay is because of the party, the court can impose actual and exemplary cost on the party at default also. Further, in case the arbitral award is passed by the tribunal within 6 months instead of 12 months, he can even be given an incentive in the form of additional fees, which may be determined by the parties. Also, while deciding an application for extension, if the court feels that delay is being caused by one of the arbitrator in an arbitral tribunal consisting of more than one members, the court even has the power to substitute that arbitrator. And in such a case, the arbitration will continue from the stage it had already reached and on the basis of evidence and material already on record, and the arbitrator appointed shall be deemed to have received the said evidence and material. So from all ends are being tried to be covered so as to ensure that the arbitration is conducted within the time frames which are provided under the Act. Another important amendment under the 2019 amendment has been made that in case such an application is moved for extension during that period, the mandate of the arbitrator shall continue till the disposal of the application. So earlier the confusion had arisen that in case an application for extension had filed, what will be the status of the proceedings during that time and whether the proceedings will be deemed to be terminated or not. So this has been clarified that the mandate of arbitrator shall continue and he can even continue with the arbitration proceedings while the extension application is being decided by the court. There is another provision with respect to fast track arbitration in which the parties can agree to get the dispute resolved through a sole arbitrator which they themselves decide. And in this case, the arbitral tribunal will not be bound by strict rules of procedure and it may not even hold an oral hearing, and in such a case, the award has to be passed within a period of 6 months. However, the arbitrator in such a case, of course, might be entitled to higher fees, and this fees has to be agreed between the arbitrator and the parties. I'll not stress so much on this since we are running short on time. Next, another important provision is with respect to post-award interest. So earlier, a very high rate of interest was prescribed under the Act that in case the award was silent, the rate of future interest from the date of award to the date of payment was provided as 18% under the Act. This was found to be not in consonance with the international conventions, and accordingly an amendment has been made that from now on the rate of interest shall be 2% higher than the current rate of interest prevalent on the date of award, so far as interest is awarded from the date of award to the date of payment. This current rate of interest will carry its definition from the Interest Act, which means the highest of the maximum rates at which interest is paid on different classes of deposits by the scheduled banks. However, it must be kept in mind that this is only in case the arbitral tribunal is silent with respect to future award. In the facts and circumstances of the case, the arbitral tribunal can, of course, award a different rate of interest. Further, with respect to costs, a specific provisions has been inserted, Section 31A, which incorporates the general principles that the unsuccessful party will be ordered to pay the cost to the successful party, and the various heads have been provided under which the cost will be paid. The one important feature which is to be noted in this provision is that the conduct of a party is a determining factor while awarding cost, and in case a reasonable offer of settlement is made by one party and refused by other parties, this is one of the factors on the basis of which the arbiter can award costs against a party. Now I'll switch to the most important section, since a lot of litigation is based upon Section 34 as to what are the grounds on which the arbitral award once passed has to be set aside. Earlier, under Section 34, the word public policy, while there was not clearly defined, and the explanation specifically started with the proviso that the condition is without prejudice to the generality of the clause. So because of the general nature of the clause, there was major scope for interpretation of judiciary. I have referred to judgment of the Supreme Court in the year 1994, in which the term public policy was defined in a narrow manner, containing only 3 heads: fundamental policy of Indian law, interests of India, justice or morality. I'll expand on these 3 just a little later. However, the need for amendment arose because subsequently in 2003, the meaning of the word public policy was expanded to hold that any award can even be set aside under this ground if it is patently illegal. Patently illegal was further bifurcated into 3 categories: if it is contrary to the substantive provisions of any law, if it is contrary to the provisions of the 1996 Act, and thirdly, if it is contrary to the terms of the contract. This expansion was further it saw further expansion in 2014 by the Supreme Court in ONGC Limited versus Western Gecko International, wherein in the term fundamental policy of Indian law, the court sought to include the Wednesbury principle of reasonableness. That is, a reasonable person acting reasonably would come upon such an interpretation, and if it is not so, then the award can be set aside. This meant that the arbitral tribunal could interfere in the merits of the award on the ground of public policy. This was found to be not suitable to international best practices, especially so far as international commercial arbitration is concerned. So the government wanted to do away with this provision so far as international commercial arbitration is concerned. So now, under the amendment, the public policy has been clearly defined, and the word only is used, which means that only these 3 conditions can be treated as the conditions in which there is a violation of public policy of India. Firstly, if the making of the award was induced or affected by fraud or corruption, and was in violation of section 75 or section 81. This is just the same as earlier. Section 75 or 81 relate to conciliation proceedings. So what is being said is that anything said or done during conciliation proceedings cannot be taken as evidence because the parties are trying to settle the matter, and if that is made the basis of an award, the award is liable to be set aside. Secondly, if it is in contravention with the fundamental policy of Indian law, this I'll explain in just a short moment. Thirdly, if it is in conflict with the most basic notions of morality and justice. So justice or morality has been changed to most basic notions, further curtailing the scope of interference of the code. Also, an explanation has been added that in public policy, the test whether there's a contravention with the fundamental policy of Indian law will not entail a review on the merits of the dispute. So while setting aside an award on this ground, the court cannot look into the merits of the dispute. This has been clearly provided by the proviso. However, so far as domestic awards are concerned, it was often felt that due to lack of trained professional arbitrators and poor quality of arbitration in India, there still needs to be scope of interference of court in certain matters where there is some patent illegality on the face of the record. So this portion of patent illegality has been inserted as subsection 2A, but with certain modifications. It provides that a court can set aside the award if it is vitiated by patent illegality. However, the proviso provides that it shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. I'll just explain this through a recent judgment of the Supreme Court as to what all categories can be interfered with or what cannot be. But one more aspect which I need to point out is under section 34(2)(a), initially the language used was the party has to furnish proof. That 34(2)(a) gives 5 grounds for setting aside an award, such as the party being under any incapacity, the party not allowed to properly present its case, or the arbitration agreement being not valid, or the composition or procedure of the arbitral tribunal being invalid. All of these grounds earlier had to be proved, but now the words have been changed to establishes on the basis of record of the arbitral tribunal. So in section 34 proceedings, if the party wants to prove any of these grounds, it has to be proved on the basis of the already existing record of the arbitral tribunal, and no new evidence whatsoever can be led with respect to this grounds. So far as all of these technical terms in the judgments, to simplify the grounds on which an award can be challenged under section 34, it is most pertinent to refer to this judgment of the Supreme Court in Sangyong Engineering and Construction Company Limited versus NHAI. I think all of us should note down this citation because this is one judgment which lays down the law threadbare as to what was the position pre-amendment and what is the position of section 34 now post-amendment. So I had informed earlier that so far as public policy are concerned, there are 3 grounds. What would they mean has been clearly explained in this judgment. Firstly, fundamental policy of Indian law. The court says it would amount to contravention of a law protecting national interest, disregarding orders of superior courts in India, and principles of natural justice, such as Audi Alteram Partem, in line with Renu Sagar Power Company Limited versus General Electric Company. So contravention of a law protecting national interest, it would, in Renu Sagar's case, it related to Foreign Exchange Regulation Act. So it would be a very serious law which affects the national interest, violation of which can be treated as violation of public policy and not a routine violation of any substantive law. It cannot be taken as violation of public policy. Further, with respect to most basic notions of morality or justice, the Supreme Court has said that in case the award shocks the conscience of the court based on the prevailing mores of the day, then it would amount to violation of the most basic notions of morality and justice. Patent illegality, as I had stated earlier, the 3 grounds which are mentioned in ONGC versus SAW pipes, first of them has been removed, that is contravention of any substantive law. Uh, However, this other two grounds are still there. The second ground being contravention of the provisions of the Act. For instance, if the arbitrator does not give any reasons of the award, this would be patent illegality, since this is in contravention of Section 31, subsection 7 of the Act, that the arbitrator has to give reasons. Secondly, if the arbitrator goes beyond the contract or his terms of reference as provided in Section 34, again, it will be patent illegality. Thirdly, while construing a contract in consonance with Section 28, as I explained, the arbitrator, he can take a reasonable view, but if his finding is based on no evidence or overlooking a vital piece of evidence, or based on documents which are taken as evidence without notice of the parties, then in such a case, it cannot be said that the award was correct, and it will be set aside on the ground of patent illegality. So certain two grounds which have now been eliminated are contravention of substantive law and erroneous application of law. In fact, in 2A, in subsection 2A, there's a specific proviso which has been added, which says so that the party that the court, one, it will not reappreciate the evidence so far as Section 34 is concerned, and secondly, it award will not be set aside on an erroneous application of law. This judgment citation, I hope all of you have noted, and another very recent judgment which has clarified the aspect as to what would amount to reasonable interpretation of a contract. I have given the SLP number. This has come very recently on 22nd of May 2020. And the court has explained that patent illegality with respect to terms of a contract, this ground will be available by following again the Wednesbury principle, that the award or the decision of the arbitrator will be perverse if it is so irrational or unreasonable that no reasonable person would have arrived at the same, or the construction of the contract is such that no fair or reasonable person would take such a contract. So if there are two views possible and the arbitrator takes one view, the court will not interfere in the same. However, if the arbitrator has taken one of the possible views, then the court should not interfere in such a matter. Well, this scope of interference, which I have explained, this is with respect to domestic awards, since most of us are dealing with domestic awards in our day-to-day working. However, this ground of patent illegality, again, I must clarify, is not applicable in case of international commercial arbitration. And that is any arbitration where a foreign individual or corporation or government is involved. In that case, this ground of patent illegality will not be available. Certain procedural aspects which we should know are also I have incorporated. While now, if we are filing an application under Section 34, we have to serve notice of the application to the opposite party, which is a necessary mandatory requirement under the Act, and also we have to file an affidavit that such notice has been served on the other party. And also, it is provided under the Act that the court shall endeavor to decide the application as expeditiously as possible, but in any case, it shall not be later than 1 year from the date on which the notice, as mentioned above, is served upon the other party. So 1 year is the outer limit within which the Section 34 application now has to be decided by the court. Coming to Section 36, this is another provision which has led to a lot of litigation in recent times. Section 36 says that earlier the provision in Section 36 provided that as soon as an application under Section 34 for setting aside the award was filed, it was deemed to be an automatic stay on the enforcement of the award. This was explained by the Supreme Court in one of its judgments, and a number of such judgments, as I've cited one of them. But now, after the amendment, the position has been changed and made quite akin to Order 41 of CPC, that in case we want to stay against the arbitral award, then the party has to file an application for stay specifically, and the court, in case it wants to grant stay, it will have to record the reasons in writing for granting such stay, and it can also impose such conditions as it deems fit. Also, if the arbitral award is for payment of money, then the provisions of CPC for grant of money decree have to be followed, such as the court can ask for furnishing of security, or it can ask that certain portion of the arbitral award amount of the arbitral award be deposited in court. So this is the change in position with respect to section 36. Quickly coming to section 37, which provides the appealable orders. One thing which we need to know is now the position has been changed with respect to section 8, and in case the court refuses to refer the parties to arbitration under section 8, this will be an appealable order, and in such a case, appeal will have to be filed with the district judge, whereas earlier all of us are used to filing revisions straight away before the High Court. However, this will apply only in cases where the court has refused to refer the parties to arbitration. In a case where the application for arbitration, referring the parties to arbitration has been allowed, in such a case, appeal does not lie, and thus such an order can only be challenged by way of revisional jurisdiction only. The other two orders are the same, that is section 9 and section 34. Another provision which I have refused to write is with respect to limitation. I need to point out here that now, since the Commercial Courts Act has come into force, in case the subject matter of the arbitration agreement is a commercial dispute having value of more than 3 lakhs now after 2018, then the order of the court will be treated to be an order of commercial court, and the first appeal will have to be filed within a period of 60 days as opposed to 90 days, as per the provisions of section 13 of the Commercial Courts Act. So the period of limitation in such cases will be reduced from 90 days to 60 days. And quickly, just winding up a few other provisions which have been inserted by the 2019 amendment. One is that all parties and the arbitral institution and the arbitrator have to ensure confidentiality of all proceedings, except in case the disclosure of the award is required for the purpose of implementation or execution of the award. Secondly, the insertion of a section 42B, whereby immunity is provided to the arbitrator for any legal proceedings against him. Then another portion is, this portion, although has not been enforced, it is with respect to creation of an institution of national importance by the name of Arbitration Council of India. So this institution will carry out the grading of arbitral institutions and as well as the accreditation of arbitrators, since the intention of the government is that in future the Supreme Court and the High Court should delegate the process of appointment of arbitrators to these institutions, and the entire process of arbitration should be governed by these institutions. However, this institution has not yet been created, and this provision is yet to be enforced. And another schedule which has been acted in the Act by the 2019 amendment also provides for the qualification, experience, and norms for the accreditation of arbitrators. More particularly with reference to us advocates, it contains the entry that we should have at least 10 years of practice in the profession. Similar is the condition for professionals such as CAs and CS. And for government and private sector officials, it is said that a person should be a senior level officer. These provisions with respect to 8th schedule, however, are yet to come into force, since the government is trying to create the infrastructure with respect to these provisions. And once the arbitral institutions are available, then the government is likely to enforce these amendments also. In the meanwhile, in March 2019, the government has already taken over the New Delhi Center for Alternate Dispute Resolution and has created it as the New Delhi Arbitration Center. And this institution is now already working for promotion, training, and conduct of arbitration. Just concluding, this is perhaps one of the most significant aspects which we need to understand, is to which category of cases the amendments will apply. So when the 2015 Amendment Act was notified, I have already given you the date of the notification, that it had come into force from 23 October 2015. Section 26 of the Act said that it shall apply to only the arbitration proceedings which are commenced in accordance with the provisions of Section 21 of the Act after the date of commencement of the Act. So far as arbitral proceedings are concerned, Section 21 says that proceedings will commence from the date a request for appointment of arbitrator is received by the respondent. So if such a request for appointment of arbitrator is received by the respondent after the given date, that is 23/10/2015, then the arbitral proceedings will have to be governed by the new act, by the amended act. And so far as court proceedings are concerned, so far as Section 34 is concerned or Section 9 is concerned, as per the wordings of the Act, in case these proceedings are filed in court after the concerned date, that is 23 October 2015, then they will be governed by the amended provisions and not by the unamended Act. However, one important aspect is in case an award was already passed prior to 23/10/2015 and a party wants to file execution of such an award, the provisions of the amended Section 36 will be applicable, because the Supreme Court has held in the judgment of BCCI versus Kochi that so far as execution or enforcement of an award is concerned, it is a procedural right, and hence it will apply to all pending cases. And even in case the award is prior to 23rd October 2015, in case of execution, the provisions of Section 36 will apply and there will be no automatic stay of award. And if you want a stay, then you'll have to file an application for stay. And only if the court grants it, then it will be deemed to be a stay on the operation of the award. The government, a controversy arose when the government tried to change this position through the 2019 amendment by bringing in a new Section 87 and omitting Section 26 altogether. And the government tried to restrict the provisions of the amended Act to those cases where the arbitration proceedings have commenced after the Act. So what the government tried to do is that if the court proceedings have started even after 23 October 2015, even then only then the amended Act will apply, and the the unamended Act will apply, and there will be no automatic stay on award. This was found to be highly unreasonable, and Justice Rohinton Nariman's bench in the Supreme Court, while dealing with this matter, struck down this amendment, saying that it did not have any proper principle behind it, and it is manifestly arbitrary and unreasonable. So the position which was there in the judgment of BCCI versus Kochi has been now restored. And so all proceedings, arbitral proceedings, which have commenced after 23rd October 2015 and court proceedings which have commenced after 2015 will be governed by the provisions of the amended Act only. So as I have said, a large-scale amendment does have been made in the Act. A unique provision has been inserted fixing timelines for the conduct of arbitration proceedings, and also for the High Court and to the Supreme Court to dispose of the applications under Section 11 or Section 34. So this Act is a very significant step, and it has managed to overcome to a large extent the problem of delays, high costs, and ineffective resolutions of disputes in our country. We are hoping that this will help in enforcing the vision of the government to make India an international hub of arbitration. And already the ranking of India has improved from 77 to 63 in the ease of doing business rankings, and from 78 to 163 in contract enforcement rankings in the world. So we do have still a long way to go. But I think if the principles which are now been incorporated are followed strictly by the courts, as well as through a proper understanding by all of us advocates, I think we will go much more far so far as these rankings are concerned, and India can in fact become an international hub of arbitration as envisaged by the government. Thank you so much. I think I'll conclude my voice with those words.
Thank you very much, Mr. Mahajan, for a well-explained and informative session. Now it's time for taking some questions. First question is by Mr. Abhishek Nagpal from Karnal. He wants to know that as Honorable Supreme Court has extended limitation, do this order of Honorable Supreme Court extends timeline for arbitration?
Can you please repeat the question?
Yeah. As Honorable Supreme Court has extended limitation, do this order of Honorable Supreme Court extends timeline for arbitration?
So far as the Supreme Court is concerned, although the judgment of the Supreme Court does not very clearly talks about arbitration proceedings. However, the Delhi High Court, I believe, has dealt with this issue specifically in certain cases, and it has said so that because of the prevailing situation in the coronavirus pandemic, it shall be deemed that in all cases the timeline for arbitration shall be extended, and it shall not be necessary for the parties in all such cases to keep filing applications for extension before the courts of law.
Thank you. And second question is by Mr. Rajendra Pandey. He wants to know that whether Arbitration Act is applicable in labor court in relation with employer and employee relations.
So the short answer is probably yes, and that is in fact the intent of the amendments which have now been made, that this issue of whether a dispute is arbitrable or not arbitrable should not normally be gone into by the courts, and as so long as there's an arbitration clause provided in the agreement entered into between the parties, the issue can be decided by arbitrators, since it is a measure which results in speedier and more effective and less expensive resolution of disputes. Can't hear anything.
I think there's a question, Prateek ji, there's a question whether the Section 29A, which enforces a strict timeline for conclusion of arbitration proceedings, but due to impact of COVID circumstances, that would also be automatically extended, or you have just answered that, so though?
Yes.
It's been asked by another viewer, Shivam ji. Prateek ji?
Hanji. Yes.
Okay. There is a question from Mr. Lav Singh Sandhu.
Yes.
He has asked whether arbitral award can be passed for remaining amount when goods in hypothecation were forcefully taken by one party and has sold those goods. So in case of hypothecation, whether it will apply, the Arbitration Act would apply or not.
Strictly, what was the extent of? Of course, this can be decided by the arbitrator, but I think this is something which will depend on the facts of the case as to what is the reason why the goods have been taken away by the other party, and this is only probably in the facts of the case the concerned arbitrator can decide.
प्रतीक जी, few questions have been asked on the YouTube as well. So अगर दो से तीन questions हैं जो important one question is being asked by advocate Shri Mohan Singh from Mohali. He asked why arbitration is a costly mechanism. He's just asking as a just asking as an opinion.
It's actually very correct. It is actually very correct. In fact, if I was listening to a webinar by Justice Indu Malhotra of the Supreme Court recently, and she has also said this, that we have seen from the last several years that usually retired judges are appointed as arbitrators, and they charge exorbitant amount of fees per hearing because they considering themselves as it after retirement, probably it is their only source of avocation. So, and also being experts in the field, they charge very high amount of fees. So this was a systemic problem which is being sought to be remedied by the Arbitration and Conciliation Amendment Act 2015 by inserting a fourth schedule in the act which provides the manner in which the fees is to be regulated. So in all jurisdiction where the High Court formulates rules as to how the fees is to be fixed in arbitration cases, then the fees will be governed with that particular schedule. For instance, now, so far as Punjab, Haryana, and Chandigarh is concerned, we have the Chandigarh Arbitration Center Rules 2018, which has adopted the schedule which is provided in the fourth schedule. So in that, a reasonable amount of fees has been fixed, which is neither too less, neither too high, so that the arbitrator is also satisfied and the parties are also satisfied that the expenses is being incurred in a reasonable, within a reasonable limit.
Pradeep ji, last two questions for the day. One is Mr. Parthesh is asking from New Delhi that will this act be able to spur international arbitration in India? I think you have already given this answer in slide, but we still need the repetition if you can.
Yes, I think this was the primary intention of the government was that as we see Dubai or Singapore or Hong Kong being the hubs of arbitration, the government feels that India is a developing economy and it has all the scope for a lot of foreign investment and commercial projects to take place. And to encourage such investment, it has incorporated all of these amendments so that the intervention of the court is minimized, especially with respect to international commercial arbitration. As I have explained, in section 34, a very important amendment has been made whereby patent illegality ground is no longer available with respect to international commercial arbitration. Secondly, international commercial arbitration will always be dealt by the High Court. So many such provisions have been inserted so that the hierarchy of courts does not take too long a time. It has been reduced, and so that international commercial arbitration is resolved in the least possible time, so that more and more countries and jurisdictions and international companies feel acclimatized to the arbitration regime in India and feel inclined to invest so far as Indian companies or Indian government is concerned.
Thank you, Pradeep ji. So now the last question for the day. Ms. Jyoti Sharma has asked the query that kindly explain the impact of amendments in Arbitration Act in relevance to the provisions of MSME Act.
I think this is something I'll have to check up because I have myself not thoroughly gone through the MSME Act.
Yes, absolutely. Absolutely.
It is a different act.
Yes,
It has its own procedure.
Yes.
Yes.
And it will prevail.
Yes.
Thank you, Pradeep ji. This was these were the last questions which we have received, and we have already received overwhelming response of all the participants. और उमेश जी ने क्वेश्चंस पूछना शुरू किया था, लेकिन शायद वो डिस्कनेक्ट कर गए, तो बाकी क्वेश्चंस हमने आपके सामने रखे हैं. I think all the viewers have given a great response and you have explained it in very nice manner. मैं अब हमारे कैशियर श्री भारत भूषण सेखड़ी जी से कहूंगा कि वो आज के हमारे कीनोट स्पीकर श्री प्रतीक महाजन जी का धन्यवाद करें.
नमस्कार सभी को. वॉइस ऑडिबल है जी?
जी हाँ, ऑडिबल.
हाँ जी.
Right. I Bharat Bhushan Sekhri on behalf of Adhivakta Parishad Punjab unit. First of all, I would like to thanks to the God Almighty, without whom nothing is possible. And after that, I would like to thank to Shri Padamkant Dwivedi ji, who is our Zonal Secretary, North Zone. And thereafter, I would like to thanks our National Council members, Shri Ranbir Kaushal ji, Shri Charanveer Singh ji, and Madam Neena Kapoor ji. And thereafter, I would like to come on the person of, or we can say, the man of the match, or who is our guest today, our keynote speaker, and Shri Prateek Mahajan ji, advocate, Punjab and Haryana High Court. Prateek ji, आज का आपका जो lecture था, it was very, very interesting. And I don't say, only I do not say this, the comments which I see on the screen while you are delivering the lectures, some of I have noted down, nicely explained, knowledgeable, very good explained. And thereafter, the nature of the questions asked by the participant or the persons who have joined this, and they shows that they have interestingly listened your lectures. I have attended all the lectures. This is our 6th online study circle. But the number of questions and the nature of questions today I see, it itself shows that yes, you have very nicely explained the concept. And thereafter, if I forgot to say thanks to our President Punjab Unit, Shri Rakesh Gupta ji, I will be definitely wrong, who is also putting good efforts. And one special thanks I would like to say to Shri Akhilesh Vyas ji, जो बहुत बहुत एफर्ट्स कर रहे हैं, ये ऑनलाइन स्टडी सर्कल्स को पूरा मैनेज कर रहे हैं, बहुत एफर्ट्स कर रहे हैं. एंड आफ्टर दैट द पार्टिसिपेंट्स जिनके बिना ये पॉसिबल ही नहीं है ऑनलाइन स्टडी सर्कल करना, सभी लोग जो स्क्रीन पे शो हो रहे हैं वो भी, और जो लोग जिन्होंने चेहरे छुपा रखे हैं पर सुन रहे हैं वो भी, उन सभी का मैं दिल से धन्यवाद करता हूं जिन्होंने इस लेक्चर में पार्टिसिपेट किया. और इसके बाद I would like to say thanks to the all the members of the Punjab's team, including me also, जिन्होंने समय निकाला और ज्वाइन किया, राइट. और सर कहते हैं कि एक अच्छी बुक 10 अच्छे दोस्तों के बराबर होती है. और मेरा मानना यह है कि एक अच्छा 30 और 40 मिनट का लेक्चर एक पूरे बुक के बराबर होता है. तो मुझे आज ऐसा लगता है कि आर्बिट्रेशन में मेरी भी थोड़ी पकड़ कम थी, तो आज टुडे इवन आई एम एबल टू गिव अ लेक्चर ऑन दिस टॉपिक. आपने बहुत अच्छा एक्सप्लेन किया, वेरी नाइसली. I formally and informally, from the core of my heart, on behalf of our Punjab unit, I would like to thanks to you, Mr. Prateek Mahajan ji.
Thank you, sir. Thank you so much. Thank you so much.